Luci Carey has a background in Australia, in Western Australia, where she got a law degree and a bar exam. Later, she moved to Singapore, and at the University of Singapore Center of Maritime Law, where she spent 5 years, she did her LLM studies and degree, and she's still connected with them as an honorary academic fellow. Then she moved to UK, first to Edinburgh, where she was teaching maritime law, and then last 3 years, she has been appointed as lecturer, as I understand now, assistant professor in commercial law at the University of Aberdeen. She is also one of the co-authors of Commercial Law in Scotland, now in the 7th edition, and publishing papers in Journal of International Maritime Law, Lloyd's Maritime Commercial Law Quarterly, and Edinburgh Law Review. Now, the topics which Luci will speak about might as well go in the tomorrow's session on autonomous vessels, because that's the area, if I understand well, also of your research in your PhD studies. So carriage of goods in autonomous vessels. But we decided to put your presentation in this first part. To announce the topic, let's say, as Michael said, when 100 years ago the story commenced with Hague rules, it was still steamships, cargo taken under the ship's tackle, telegrams were used and letters, and no one even dreamed about telex, let alone about email, about electronic documents or blockchain technology. And even during the Rotterdam Rules creation, nobody dreamed about ships without crew, unmanned ships and autonomous ships. So technology is always moving faster than the legal rules and legal framework which should regulate it. And now we will see how the things will be developed concerning carriage of goods on the autonomous ships. So please, Luci, the floor is yours.
Thank you very much, and thank you for your patience while we managed to find the slides. Can you hear me okay? Thank you very much, Igor, for inviting me to come and speak today, and for the International University Centre for hosting us so beautifully. And a special thank you to Frank Stevens for swapping his spot today with me to accommodate my schedule, which is hectic due to spectacularly bad planning on my part. I managed to double book myself. And as a Harry Potter style time turner has not been invented yet, for those of you who've not read Harry Potter, the time turner enabled a very studious student called Hermione Granger the ability to attend several classes at the same time. But as that hasn't been invented, or I haven't been granted one, I'm only able to join today, which is a great shame, because Dubrovnik is spectacular. I've never been here before, and the rest of the schedule looks really, really good. So I'm a bit sad to be missing it. As Igor explained, the title of my presentation will be Carriage of Goods and Autonomous Ships. And like Harry Potter, some of this discussion will venture into fiction, because I am discussing the future, which is always a little bit risky, because the future is, as we know, uncertain, or the only thing that's certain is it's uncertain. And when trying to predict what will happen, that means there's a very high chance that I will be wrong. So that said, in an academic context, it means lots of citations, because that's always good, even if those citations are pointing out the folly of my arguments. So in an attempt to mitigate the risk of being wrong, for the purposes of this presentation, I will explain, first of all, the various types of autonomous vessel operations that are currently underway and proposed future operations, before looking at the problems that arise when we are talking about crewless operations, and in particular, what challenges are anticipated for the application of sea carriage conventions, namely the Hague and Hague-Visby rules, Hamburg rules and the Rotterdam rules, before considering what the path or the passage forward for the introductions of these types of vessels could be. So before I move to the discussion, just some brief definitions. Those of us who have been closely following and watching the development of maritime autonomous surface ships, or MAS, and obviously I assume last year's conference attendees will be very familiar with this. But by way of reminder, the IMO has defined a MAS as a ship which to a varying degree can operate independent of human interaction. And then the degrees of autonomy are defined as follows. So we have degree 1, a ship with automated processes and decision support. Seafarers are on board to operate and control shipboard systems and functions. Some operations may be automated and at times be unsupervised, but with seafarers on board ready to take control. Degree 2, the remotely controlled ship with seafarers on board. The ship is controlled and operated from another location, and seafarers are on board ready to take control and operate the shipboard systems and functions. Degree 3 is the remotely controlled ship without seafarers on board. The ship is controlled and operated from another location, but there are no seafarers on board. And then degree 4 is our fully autonomous ship. So the operating system of the ship is able to make decisions and determine actions by itself. So currently, remote operation centres, or ROCs, are being used for the operation of smaller craft. So the ROC is a centre where a person or a team of people can operate and monitor offshore vessels remotely. This requires constant connectivity between the ROC and the vessel using a combination of satellite, 4G network, or fibre cables. The ROC is crucial for the successful operation of a voyage, and it has been described as embodying the heart of mass operations. For example, marine survey companies use uncrewed vessels, they call them USVs, to conduct offshore inspections of subsea pipelines and offshore facilities. And we actually have one of these centres in Aberdeen because we have, as you might know, that Aberdeen is a sort of oil and gas hub, but now is transitioning to offshore wind and offshore energy. So we have a centre that's actually in Aberdeen that's conducting these operations currently. The USVs are about 12 metres in length. Some can go up to 24 metres. They're operated remotely by human operators on shore in real time, as if they're controlling from a conventional bridge. So these operations would be categorised as degree 3 in the IMO taxonomy. In terms of cargo carrying operations, a vessel that has received much in the way of publicity over the years is the Yara Birkeland, which has been operational in Norway's coastal waters since 2022. This is an electric cargo carrying ship, and while it's currently operating with an onboard crew, it is using autonomous systems in preparation for future fully autonomous voyages. And in addition, there are several ongoing projects which are preparing for the introduction of uncrewed cargo and passenger carrying vessels. So, for example, Fjord 1 is an operator of a fleet of ferries in Norway, has ordered 4 ferries with a view to fully autonomous operations. And in Japan, the Nippon Foundation's Meguri 2040 project is in stage 2 of the aim of achieving fully autonomous navigation. The motivations behind these projects vary, but in general, remote operations have the goal of being safer, with lower emissions, in particular for surveying operations. For cargo and passenger carrying vessels, the drive to autonomy is due to an increasingly shrinking seafarer labour force. And this issue has actually been argued that it could be exacerbated by the increase in ROCs, because experienced seafarers could be poached from an already shrinking pool to train ROC operators. Other perceived benefits include reduced operations, voyage and crew costs, And then the potential to integrate mass into the Internet of Things within logistics and supply chains. So unlike conventional ships, when a mass is operating at degrees 3 and 4, so the ship is navigated and or monitored by an operator in a different location rather than being on board, this is a bifurcation of the vessel and the bridge. Now, the IMO is developing a regulatory framework for the safe operation of mass, and the IMO has explicitly stated that a mass must have a human master, or the equivalent of a human master, regardless of the mode of operation, including remote operations. So what this means is that there will be a person in a totally different location from the vessel who has the responsibility for the vessel's operations. Now, this could be actually navigating the ship itself, which would reflect degree 3 in the level of autonomy. Or if the ship is navigating at degree 4, then the person would be monitoring the operation from either a shore-based location or potentially in a remote operations center on board another ship. There is also the possibility that this person, who is defined as the master, will be responsible for more than one vessel at the same time. So while there would only be one master per ship, this person may be the master of 3 or 4 ships simultaneously. So this is a potentially novel operation for the international carriage of goods by sea. And as I foreshadowed, this may be fictional. We're not there yet. But it is worth considering how the existing maritime cargo regimes would function when the crew is taken from on board the ship to on shore. So I propose looking at 3 issues, and I'll look at them in each term. And what I will do is just draw comparisons between the Hague Rules and Hague-Visby Rules, which I will bunch together for simplicity, the Hamburg Rules and the Rotterdam Rules, to generally identify how each regime would accommodate cargo carrying mass. So the 3 broad issues will be the scope of application of the convention, how will a carrier fulfill its obligations when a ship is uncrewed, and how would we determine the carrier's liability. So to begin with the first issue, what is the scope of the convention and does it apply to remote operations? And I would submit that this is straightforward and unproblematic. The Hague Rules apply to a contract of carriage covered by a bill of lading in any similar document of title from the period of time when the goods are loaded onto the time they are discharged from the ship. Ship is defined as any vessel used for the carriage of goods by sea. So our remotely controlled craft is a vessel. It's used for carrying goods by sea. There is nothing that says that a crew must be on board for it to be a ship. Therefore, even if the operational navigation of the vessel is a different location, provided a bill of lading is issued, the Hague Rules would apply. The Hamburg Rules do not define a ship, but does define the carrier and the actual carrier. Again, a bill of lading is issued in a contracting state of the port of loading or discharges in a contracting state. The Hamburg Rules would apply. There's nothing in the text that would preclude the operating ship being covered. The Rotterdam Rules will also apply, and the scope of application is wider than that of the Hamburg Rules and the Hague-Visby Rules. And the definition of ship in the Rotterdam Rules means any vessel used to carry goods by sea. So therefore, our remotely operated vessel can meet that definition, because there is nowhere that it says that there must be, or it's expected that there is a crew on board for it to be considered a ship. What is a more thorny question, though, is how will the carrier meet its seaworthiness obligations? Article 3.1 of the Hague-Visby Rules and Hague Rules specifies that the carrier shall be bound before and at the beginning of the voyage to exercise due diligence to make the seaworthy and to properly man, equip and supply the ship. The Hamburg Rules do not contain a seaworthiness provision, but Article 5 provides the basis of liability. So if the occurrence which caused the loss, damage or delay took place while the ships were in its charge, as defined by Article 4, unless the carrier proves that he, his servants or agents took all measures that could reasonably be required to avoid the occurrence and its consequences. And then the Rotterdam rules provide at Article 14, the carrier is bound before and at the beginning of and during the voyage by sea to exercise due diligence to make the ship seaworthy, properly crew, equip and supply the ship, and keep the ship so crewed, equipped and supplied throughout the voyage. So while the Hague rules and the Rotterdam rules both have this express seaworthiness requirement, the duty under the Hague rules only applies before and at the beginning of the voyage, whereas it's a continuing obligation under the Rotterdam rules. So with regards by what we mean by seaworthiness, the first issue is therefore, what has to be seaworthy? Is it the craft or the vessel on its own, or does it extend to shore-based remote operations centre? So that requires thinking a bit about what we mean with seaworthiness. A ship owner may not benefit from the exclusions in the Hague rules if they do not exercise due diligence to make the ship seaworthy before and at the beginning of the voyage. Now, in the context of autonomous ship operations, this provision is generous because it is not a continuing obligation, unlike the Rotterdam rules. But both conventions do not make seaworthiness an absolute requirement. It's the exercise of due diligence that must be satisfied for the carrier to have met its obligation. Now, when we're talking about conventional ships, seaworthiness means proper manning, proper passage planning following the CMA CGM Libra, and a proper safety management system. So proper manning is interesting in that there will not be a crew on board the ship. However, the ROC operators are considered crew and a master, and so they will be required to be competent and sufficient in number for the vessel to be considered seaworthy. Under the Hague rules, if the responsibilities are delegated to independent contractors and those people are negligent, then the carrier still remains liable. So the carrier may not argue that it engaged reliable experts or lacked the necessary expertise to check their work. And there's no case in which a failure of due diligence by the master and officers has been held to be outside the orbit of the shipowner's responsibility, and it's hard to think that there would be. Following the UK Supreme Court's reasoning in the CMA CGM Libra, I would argue a remotely operated centre or remote operations centre, which is not run by the carrier itself, but by a third party, would still come under the provision of seaworthiness or the requirement of seaworthiness. However, the duty of due diligence does not, to provide a seaworthy vessel, does not extend responsibility to manufacturers, exporters, or shippers. So that means that the carrier does not need to check what's being shipped. And furthermore, a carrier may avoid a claim under Article 3, Rule 1 if it can show there is a latent defect arising from the construction of the vessel, provided that it can produce evidence that no defect is discovered during inspections carried out by surveyors. If, therefore, the remote operations centre is deemed to be part of the ship for seaworthy requirements, which I would submit it surely must be, then there will have to be some form of inspection and probably licensing or a survey of the remote operations centre itself in order for the carrier to meet its seaworthiness requirements. Its due diligence requirements. So the standard is due diligence, which is indistinguishable from an obligation to exercise reasonable care, and then a lack of due diligence is therefore negligence. When it comes to proving seaworthiness, Article 4, Rule 1 places the burden of proving due diligence has been exercised on the carrier, so that means there's a positive obligation on the carrier to prove that it exercised due diligence. But in a cargo claim under the rules, it is for the claimant to establish a prima facie case against the carrier. The carrier can respond to this prima facie allegation by pleading and proving an exception under Article 4, Rule 2. The claimant can displace the carrier's defence by proving there's been a breach of the carrier's obligation of due diligence. And what this means is that it must prove the ship was unseaworthy before and at the beginning of the voyage, and that this defect was responsible for causing the damage or loss complained of. Now the carrier has to show that it exercised due diligence. However, this may be difficult for a claimant because they're going to have to prove that unseaworthiness not only caused the loss or damage, but that it was unseaworthy at the beginning of the voyage. Under the Rotterdam rules, this worthiness obligation is ongoing. And given that the ship will be constantly monitored from an onshore location, look, this is arguably a reasonably easy obligation to meet. However, if the uncrewed vessel becomes unseaworthy during the voyage, for example, if it is holed or it's damaged in some way, then the remote operations centres will be required to arrange assistance for the vessel to remedy the problem, which means that they likely have to engage salvors. The 1989 Salvage Convention authorises the ship owner to bind the cargo to a salvage contract if the property is in danger. But if there is a false alarm that's indicating that the ship has become unseaworthy, when in fact, so for example, if a sensor indicates that something is wrong, but in fact it's the sensor that is faulty, then we could potentially see disputes arise between the carrier and cargo related to the salvage operation. So arguably, the Hamburg rules are the most suitable in the sense that there is no express obligation, and then the burden of proof is on the carrier to show that it took all measures that it could to be reasonably required, and this burden also extends to servants and agents. So if the remote operations centre is not operated by the ship owner but is outsourced, then the remote operations centre would be considered a servant or agent of the ship owner. And so thus it is for the carrier and not the cargo to displace the burden. So moving on then to how the carrier will meet its obligations to care for cargo. The Hague-Bisbee rules require under Article 3.2 subject to the provisions of Article 4, the carrier shall properly and carefully load, handle, stow, carry, keep for and discharge the goods carried. Properly and carefully means in accordance with a sound system, and the application of that system must be careful. So a sound system generally means in accordance with general industry practice. And the burden of proving compliance is on the carrier following the UK Supreme Court's decision in the Volcaf case, and relying on exceptions in Article 4 also appears to be on the carrier. The Hamburg Rules, Article 4, Rule 1, the responsibility of the carrier for the goods under this convention covers the period during which the carrier is in charge of the goods at the port of loading, during the carriage and at the port of discharge. And then Article 5.1 provides a basis of liability. So the carrier will be liable for loss or damage to goods, as well as for delay in delivery if the occurrence which caused the loss, damage, or delay took place while the goods were in its charge. Unless the carrier proves that they took all measures that could be reasonably required to avoid the occurrence and its consequences. The Rotterdam Rules, Article 13, Rule 1, the carrier shall, during the period of its responsibility, as defined in Article 12 and subject to Article 26, properly and carefully receive, load, handle, stow, carry, keep for, and load and deliver the goods. So there is nothing to prevent these rules from applying to mass operations, but there may be practical considerations in how the carrier can actually comply. Because firstly, if the vessel has no crew, then the loading and discharge operations will be presumably carried out by third parties on behalf of the carrier, such as stevedores, or alternatively by other remote operations, so remotely controlled cranes. This duty to properly and carefully load and handle may be delegated by the carrier, but the liability will remain with the carrier itself. Once at sea, the duty to care for the goods will rest with the ROC operator, who is monitoring the voyage. So this monitoring will require the use of sensors and possibly robots, which will send data back to the ROC. And then analysis of the data will be through the use of statistical and artificial intelligence tools. In the event that there is a risk to the cargo, the duty will rest on the master in the ROC to engage salvage services, which, as I mentioned, will potentially bind the cargo interests. But I have wondered if this type of monitoring, these advanced monitoring systems would actually find their way into becoming the industry standard for properly and carefully caring for goods on conventional ships, if they are proven to be more effective. Just last week, the Marine Accident Investigation Bureau in the UK issued an interim report on the collision that happened in the North Sea between the Solon and the Stena Immaculate. And it noted in its report that humans do not make good monitors, and if understimulated, they will find other things to occupy themselves. So, and it recommended greater use of autonomous systems in ships. So the Hague Rules, Hamburg Rules and Rotterdam Rules all contain provisions on liability and defences available to the carrier. I don't propose to go through them all in turn, but I'd like to highlight some that might be affected by autonomous operations. So firstly, the notorious nautical fault exception in the Hague Rules. If there's no onshore person navigating, rather it is the software or the AI system that is in charge of the navigation, and that software system or the AI is negligent, then it's unlikely that could be considered the act of a master, mariner, or a pilot. However, if there is an onshore operator who's navigating and does something negligent by misusing the navigation system, then it is likely that the carrier would be provided the benefit of this defence. All three regimes contain a provision of fire. Although fire is an accepted peril, this doesn't mean that the carrier would not need to have fire extinguishing equipment on board their autonomous vessel, their mast, that would have the same firefighting capability of an onboard crew. So if it doesn't have any firefighting equipment, then it may be considered a fire that results from failure to exercise due diligence to make the ship seaworthy. The carrier will also be accepted from liability if the damage results from latent defects not discoverable by a competent person using ordinary care. So under the Hague Rules, such defect must not have been discoverable before and at the beginning of the voyage, but the Rotterdam Rules would make this condition applicable for the whole voyage. So if the defect would have been discoverable, then the ship is unseaworthy. Whether or not latent defects in software would be covered by this exception is less clear, but in my opinion, that is unlikely. And if I could quote Lord Hodgson in the 1961 case, the Muncaster Castle, he said back then, "It is true that ships have become more and more complicated since the days of sail, and complications have no doubt multiplied since the passing of the Act of 1924. But this does not justify a more lenient construction being put upon the Act in favour of the enemies. The obligation in Article 3 is not subject to any other qualification, and it is generally recognised that the Act was not passed for the relief of ship owners, but to standardise within certain limits the rights of the holder of every bill of lading against the ship owner." So I think this would still stand true for latent defects in software today. So where do we go then? How are we going to do, what is the way forward with MAS and international sea conventions, sea carriage conventions? The sea carriage conventions obviously were not drafted with uncrewed operations in mind. And given the current lack of appetite for new conventions or treaties, and it's likely we will have to just shoehorn autonomous vessels into the existing ones. So rather than trying to amend the conventions, it is possibly preferable that clauses in bills of lading are inserted instead for autonomous cargo services, provided those clauses do not derogate from the applicable convention. This could be a straightforward solution. What is not so straightforward, though, is drafting such clauses, but I will choose to leave that for another day. Thank you.